The Max M. Shapiro Lecture is delivered each year by a distinguished guest. This is our principal endowed lectureship at the School of Law, and we've been privileged to host some exceptional legal scholars, practitioners, and others over the years. And you can see a list of our prior presenters on the last panel of your program. I'd like to tell you a little bit about Max Shapiro, for whom the lectureship is named. Max graduated from Boston University School of Law in 1933, and he quickly made a name for himself as an outstanding trial lawyer practicing in New London, Connecticut. He was a recognized leader in the profession and served as president of the Connecticut Trial Lawyers Association. Throughout his 60-year legal career, he embraced the role of mentor, inspiring and instructing younger attorneys by the strength of his example. And Max never stopped thinking about a lawyer's duty, and he never stopped caring about the law school from which he graduated. When Mr. Shapiro died, his son, Andrew, from the class of 1977, and his daughter, Sue Ellen, who's also a lawyer from Case Western Law School, and his son-in-law, Larry Cadis, established a fund in his name for an annual lecture. The Max M. Shapiro Lecture is a fitting tribute to the memory of a lawyer and a mentor who was devoted to examining the place of legal ethics in trial advocacy. On behalf of the law school, I'd like to welcome the Cadis family, Larry, Sue Ellen, and their daughter Samantha, and to thank Sue Ellen, Larry, and her brother Andrew, who couldn't be here today, once again for making this lectureship possible. So today we continue our tradition with our distinguished guest lecturer, Barbara Babcock, who will speak to us about the origin of the public defender system. Barbara is a graduate of the University of Pennsylvania and of Yale Law School, where she was a member of the Yale Law Journal and the Order of the Coif. She began her career as a clerk for Judge Henry Edgerton of the U.S. Court of Appeals for the District of Columbia Circuit. She was later hired by defense attorney Edward Bennett Williams and learned to represent defendants with plentiful resources available. In 1966, she joined D.C.'s fledgling legal aid agency, and 2 years later, she was named director of the district's first public defender service, where resources were somewhat less plentiful. In 1972, she accepted an offer from Stanford Law School, becoming the first woman professor to be hired and subsequently tenured there. During a leave of absence from Stanford, she served as Assistant Attorney General for the Civil Division of the Department of Justice in the Carter administration. There, she supervised 700 lawyers who handled more than 40,000 cases involving the United States annually. During her time at Stanford Law School, Professor Babcock has become known as a gifted teacher, dedicated mentor, and great storyteller. She's one of the nation's leading authorities on civil and criminal procedure and wrote the first legal textbook on sex discrimination. She's also known for her research into the history of women in the legal profession. In particular, she has studied the life and work of Clara Shortridge Foltz, the first woman admitted to the California bar and the first person to propose and champion a public defender system. Today, Professor Babcock will tell us about the life and work of the remarkable Clara Fultz, a pioneer in the legal profession, trial attorney, suffragist, and all-purpose reformer. After her remarks, we'll have some time for questions. Please wait for the microphone to make its way to you, because we're taping today. And after the conclusion of the program, we'll have a reception in the lobby area of the law auditorium. So without further ado, Barbara.
Thank you, Dean O'Rourke and the Cadis family for this opportunity to bring Clara on the road. I want to talk to you today about the true story of how the public defender movement began. It's a little-known history of public defense, and I'll conclude by saying that the great social dislocations and grave professional ills that gave rise to the idea in the first place are with us again, or perhaps still with us today. Now, I graduated from law school the year that Gideon versus Wainwright was decided, 1963, the case in which the Supreme Court said that the Sixth Amendment guaranteed the right to counsel, to free counsel in serious criminal cases. It came down in March of 1963, just as I was about to graduate, and I thought, wow, here I am just getting out, and the revolution is beginning. Because from a tender age, I had planned to be a criminal defense lawyer, and now the Supreme Court was creating a tremendous need for criminal defense lawyers. 9-0, 9-0. It was so inspiring to begin law practice in those heady days when the Warren Court was at one end of the street, the D.C. Circuit, headed by the most liberal judge concerning criminal matters ever to sit in any court in any country, David Bazelon, was just down the road, and across the street was the Justice Department, a real Justice Department, led by Bobby Kennedy. Though Gideon was unanimously decided, it was not a slam dunk case. The criminal justice system was still reeling from Mapp versus Ohio, decided just a year earlier, which applied the Fourth Amendment and its exclusionary rule to the states. Now, all the arguments about federal interference with local procedure that Mapp had stirred up applied in spades to the counsel issue. If due process required a lawyer in every serious case, this affected the practice in every courthouse in the country, from the smallest hamlet to the New York metropolis. The court appointed the consummate D.C. lawyer, Abe Fortas, to brief and argue Gideon's pro se petition. He conducted an intensive study of the huge difference a lawyer can make in any case, no matter how seemingly clear and simple. Gideon himself won on retrial with a top local lawyer representing him. Now, that's the history of the right to counsel and of the public defender. But what I want to give you today is the prehistory. And first, think about the idea of public defense, that the state should pay for the defense of those it believes have violated its laws and statutes, that the state should provide the kind of intimate individual service involved in defending. It is truly a radical idea, communistic, socialistic, incredibly idealistic to even think about the possibility of doing it. And yet today, public defenders are everywhere throughout the vast, decentralized bureaucracy that is our criminal justice system. They're on federal, state, and county levels. And yet there is no government institution even vaguely like the public defender. And it still is not, even though it is ubiquitous, very widely understood or supported by the public. So where did the idea come from? It was a pioneer woman lawyer, Clara Foltz, lawyer and suffragist, who started the public defender movement with a speech at the Chicago World's Fair in 1893. And then she drafted a model statute and arranged for its introduction in a dozen state legislatures in 1897. She herself took it to the premier state legislature in New York. She also wrote 2 scholarly articles on public defense and published them in the leading law reviews of the day. Even from the beginning, though, the public defender idea was far from universally applauded. A female attorney's strange project, sniffed the New York Times. A ridiculous thing for the state to prosecute with one hand and defend with the other the violation of its own statutes, said the New York Tribune. Now, who was Clara Foltz, and where did she get this idea? When Clara Foltz spoke at the World's Fair in 1893, she was one of a tiny band of women lawyers in the country, 208 according to the 1890 census. And most of them were, like their 20,000 or so male counterparts, local practitioners, hardly known beyond the courts in which they appeared. Clara Foltz, by contrast, was a celebrity. You would probably have known her name if you lived in that period. Her fame started when she fought to become a lawyer and to attend law school in Northern California in the late 1870s. Deserted by her husband in the midst of an economic depression, Clara Foltz turned to the law as a way to support her 5 children, none old enough to earn the milk it drank, as she always said. She first led an effort to change the California Code, which provided that only white men of good character could be lawyers. She took white and men out of the statute and replaced it with persons. Then Foltz used the newly minted statute herself to the accompaniment of worldwide publicity, dubbing her the Portia of the Pacific. The first woman hyperbole had hardly passed before the next wave of publicity gathered around Fultz's effort to attend the newly established Hastings Law School. And a number of people who were already lawyers wanted to go to law school because they had just read law and there hadn't previously been a law school in California. So this was a chance to learn the theory. And she was one. She was refused admission, even though she was already a bar member, because she was a woman and the rustling of her skirts would bother the other students. Fultz did what any lawyer in her situation would do. She sued him. And she successfully argued that Hastings was part of the University of California, which had been coeducational since its founding. For good measure, Fultz and her suffrage friends lobbied through an amendment to the California Constitution, providing that no person shall, on account of sex, be disqualified from entering upon or pursuing any lawful business, vocation, or profession. It was the first such clause in any American constitution. Now, Fultz's story was well known in her day, and it gave credibility to her public defender campaign. Having surmounted almost inconceivable barriers herself, she could hardly be dismissed as a mere theorist or an overly sympathetic female or one ignorant of the harsh realities. But where did she get this idea? How did a seriously undereducated single mother of 5 living in the far West long before women had political equality conceive an entirely new way to practice law? The most important influence was her own experience as a woman lawyer. As an outsider and a newcomer to the criminal courts, Fultz saw the injustice that was ignored by the regular people who went there. She said these men were deadened in feeling by constant contact. As a woman, she observed such telling details as the soiled linen, the whiskey breath of the shyster, as well as the innocents, boys and girls, as well as men and women, too dazed to understand their rights and legal position, as she said. She also saw the incompetent appointed lawyers at work. So it was not a great mental leap from Fultz's firsthand observations of the terrible injustices in the criminal courts to the idea that the government was responsible for a fair presentation of both sides of the case. It was not only what she learned from her underdog clients, but how their position combined with her own as an underdog litigator that brought her to the idea. And so I want to tell you the story that is central to one of her favorite stories that is central to her conception of the public defender. But I'm just going to get a little water before I do that. But so this is one of Fultz's favorite stories that is the basis for her public defender idea. And it encapsulates how her experiences as a woman lawyer connected with the invention of the public defender. She came to court one day in San Francisco in the late 1880s. She had been in practice for a decade at that time. And on the spot, the judge appointed her to represent a man on trial whose attorney had not appeared. At that time, in most places in the United States, any attorney who showed up in court risked being appointed in this fashion. But it happened more often to Fultz. Now remember the history of the right to counsel, which is, this is the history that Clara Fultz often related in her speeches and articles. At common law in England, out of the midst of the common law, there was no right to counsel at all for the defense. That is because most serious crimes were capital offenses, and the state was under a duty not to even prosecute unless the evidence of guilt was overwhelming. The prosecutor, the public prosecutor, was also supposed to present all evidence favorable to the accused, and the judge was also thought to look out for the rights of the defendant in the serious criminal case. Now, Americans, right from the beginning, didn't go for this idea, and every colony and then every state had a right to counsel, the equivalent of the Sixth Amendment, included in its constitution. But it was only for those who could pay the right to counsel. And then courts started appointing lawyers, and lawyers considered it a professional pro bono type duty to represent the indigent criminal. But there was no really organized system for doing that. In a few states, led by Wisconsin in the 1870s and 80s, the courts said that the government should pay these appointed lawyers. They weren't appointed systematically, but in serious cases, some judge would do it. In California, however, these precedents were rejected just a few years before Foltz joined the bar, so that most of the criminal cases that she did, and she did many criminal cases, were for poor people, in which she was either appointed by the court or other lawyers sent her their non-paying cases, or the poor people sought her out. Poor, desperate people accused of crime, practically the only ones brave enough or desperate enough to go to the only woman lawyer in the state. She was appointed especially often after she started advocating criminal justice reforms and calling for a public defender, elected in the same manner and paid out of the same funds as the public prosecutor. Ruefully, she noted that the judges of the criminal departments laughed at the idea of a public defender as chimerical, but they frequently appointed me to defend those who were unable to employ counsel. I suppose this was intended as a sort of tryout of my own doctrine. Now, her latest client was a young Italian immigrant who barely spoke English. She took her place by his side. Remember now, she's only one of two women in the courtroom: the judge, the jury, the courtroom personnel, the witnesses, the spectators, all men. The only other woman in the audience was the defendant's wife. Clara Foltz listened to the district attorney deliver his opening statement, promising to prove that the accused set fire to his own house, a hovel on Telegraph Hill in San Francisco, in order to collect $500 in insurance money. Deputy District Attorney Thaddeus Stonehill was a man as solid and formidable as his name implied. Combat veteran of 2 wars, Stonehill had, according to Fultz, been a captain in the Southern Confederacy, but by common consent, everybody called him Colonel, after the manner of those gallant, loving-hearted Southern people who seemed never to weary in their friendly intercourse with each other. From the very outset of the case, she said, I believed in the defendant. This state of mind is a habit with me. I believe in my client's cause. She proceeded to cross-examine vigorously and put on an alibi defense, the classic defense of an innocent man. If you were so unfortunate as to be charged with a crime that you did not commit, where would you be? With your enemies? With somebody who's keeping a record? No, you would be home with your wife and children. For Stonehill, the Southern Cavalier, the whole defense was a nightmare. He saw himself on the verge of defeat at the hands of a woman. The word would be on the street before the jury was dismissed, and a laugh at his expense would be mandatory at the lodge and in his clubs. As the evidence wound down, Colonel Stonehill turned to the ultimate weapon in the prosecutor's arsenal. He would make the first and the last summation to the jury. Stonehill's scheme was to spend his first jury speech assaulting Clara Foltz, not even mentioning the evidence in the case. Instead, he would arm the jury against her slick oratory and her feminine wiles. Then, in his rebuttal, when she had no chance to respond, he would discuss the evidence. It's an old trick. Defense lawyers call it sandbagging. How Foltz described it: Colonel Stonehill was at his best. I looked calmly on as he flayed ambitious women who have no sense of the fitness of things, parade the streets or enter the forum to show off. Women who have no child, I had 5, no husband, I was a widow, actually divorced, but it was better to be a widow. No home. I had the dearest, cleanest little home in San Francisco. She is a woman, bellowed this learned limb of the law. She cannot be expected to reason. God Almighty decreed her limitations, but you can reason, and you must use your reasoning faculties against this young woman who will lead you by her sympathetic presentation of this case, reeking with the vilest guilt, to violate your oaths and let a guilty man go free. Now, news had gone out that there was a good show in Judge Farrell's court, and the room was crowded by the time Clara Foltz rose for her summation. She turned on her opponent not the bludgeon of accusation, but the stiletto of ridicule. In metaphors and in poetry, in jokes and wicked asides, she assailed Stonehill's intelligence, his sobriety, his manhood, and his manners. Here's a small sample. She is a woman. Foltz rang so many changes on these 4 words. With mock sympathy, she intoned, "Counsel has sat here for many hours, almost choked to suffocation with this mighty thought." Possibly it was the tremendous weight of this idea that sometimes made his step unsteady, his cheek more flushed, and his nose a deeper crimson. Counsel intimates with a curl on his lip that I am called the lady lawyer. I'm sorry I cannot return the compliment, but I cannot. I never heard anybody call him any kind of a lawyer at all. And now let us take it all together. I am a woman, and I am a lawyer. And what of it? It is not so new and wonderful a thing. I am practicing law in this city. I have offices in one of its largest buildings, and I go daily to and from those offices, sober and in my right mind. I ask no special privileges. Here's Fultz's credo, and I expect no favors. But I think it only fair that those who have had better opportunities than I, who have had fewer obstacles to surmount and fewer difficulties to contend with, should meet me on even ground upon the merits of law and fact, without this everlasting and incessant reference to sex, reference that is in its very nature uncalled for, unprofessional, and unmanly. Her self-defense completed, Foltz turned the advantage she had gained to the service of her client. She had shown Stonehill as the overzealous prosecutor who would insult a lady and a jury in the same breath. Now she argued that in his selfish ambition to win, he had deliberately pursued an innocent man. Knowing that she had them, Foltz let out all the stops. Now remember, this is an all-male jury. In the name of the mothers who nursed you, and of the wives and maidens who look love into your eyes, I resent this hidden appeal to the supposed prejudice of this jury. I resent the covert innuendo that the presence of woman in a lawsuit contaminates her, and that her sex must militate against her client. And I resent for you, gentlemen of the jury, the implication that you are small enough and narrow enough to bring prejudice into this jury box. Despite the fact that Stonehill roared like a bull out of Bashan in his rebuttal, the jury acquitted without leaving the box. When Foltz told this story, which she very often did, the moment of acquittal was not the end. Outside the court, I stood talking with the happy man and his clinging, loving young wife. They both appealed to me as though they each were of my own flesh and blood. I watched them as hand in hand they went toward the half-burnt shack on Telegraph Hill. The innocent man, walking free into the sunset, was the romantic vision behind the public defender idea. She found inspiration of a different sort in Stonehill's personal attack. It made her see how much the public defender touched on her own self-interest. She knew it would change everything for the criminally accused to be represented by a lawyer endorsed by the state and backed by its full resources, and it would also change everything for the woman lawyer representing the poor accused if she had a title from the state and a position from the state. A public defender would elevate the representation of the criminally accused so that all reputable lawyers, especially women, could do the work. Now, the case most directly connected to Fultz's public defender idea was one she tried in 1892, some years later than the case of arson. Before his arrest, James Wells had been a successful real estate man with an office near Fultz's in San Francisco. He was broken in jail when she defended him on a forgery charge. At trial, she told the jury, "I deplore the fact that the law does not provide for a public defender as well as a public prosecutor. Do you think this poor, innocent man would have applied to a woman to defend him if he had the money to pay some distinguished male member of the bar?" Not a proper argument, don't try it, but in the 19th century, she says, "I am in this case without pay or the hope of reward." For 5 days, Clara Foltz and the district attorney were locked in heated adversarial combat. She objected to his unfair conduct of the case from opening statement on to the urging of improper instructions and a mendacious summation. The jury went out at 4:20 in the afternoon. By 8, they had a verdict, guilty as charged. The Chronicle sketch artist showed the tearful defendant slowly sinking his head almost into the lap of his counsel, who tried to pacify him by consoling words. Bitterest of all, perhaps, was an editorial about Fultz's impassioned jury plea, which inveighed against women lawyers whose object is to pervert justice and to soften the stern conclusion of reason, a tendency of women that has often been urged against the enfranchisement of their sex. Fultz filed a forceful appeal, complaining of the prosecutor's conduct, and ultimately she won a reversal from the California Supreme Court on the basis of prosecutorial misconduct, a kind of an amazing result. The court said if a defendant cannot be fairly convicted, he should not be convicted at all. It was a great victory for Fultz, and it became a major precedent on prosecutorial misconduct. But I'm getting ahead of the story. Shortly after she filed the brief in Wells, Fultz was on the prestigious platform of the Congress of Jurisprudence and Law Reform, which was one of the great auxiliary meetings held in connection with the World's Fair. Just to give you an example of the prestige of this occasion, James Bradley Thayer, the Harvard professor, spoke on the origin and scope of the American doctrine of constitutional law, probably the most famous article ever written on constitutional law. John Henry Wigmore spoke on the administration of civil justice in Japan. David Dudley Field spoke on the codification of American law. And Clara Shortridge Foltz spoke on public defenders. It was the first time a woman lawyer spoke on an international stage with men lawyers, and her speech brought down the House. Now, I don't have time now to tell you the story of how she came to be there, which you'll have to read the book, but let me set the stage briefly. Foltz was 44 years old, though she looked and claimed a decade less. And she had these children when she was a child herself. And she was a great orator. She made the overhead for her office by public lecturing. She had a powerful, melodious voice, and she spoke with passion and sincerity. She was also beautifully dressed. Dress reform was the only reform of the 19th century which did not interest her. She was interested in high fashion, whatever it demanded, and she always wore fresh flowers in a corsage. Her speech on the platform with these heavy-duty, double-domed male intellectuals, her speech had a muckraking tone, and she had the tone of speaking truth to the jurisprudents, most of whom had never been in a criminal court. She summoned all the men who opposed her over the last 12 years in a composite of the public prosecutor, strong of physique, alert of mind, learned in the law, experienced in practice, ready of speech. Taking language almost verbatim from the brief she had just filed in Wells, she pictured the full power of the state against the accused, and then asked, "But what machinery is provided for the defense of the innocent?" And answered, "None, absolutely none. For the lesser duty of convicting the guilty, the state has equipped and maintains an army. For the higher one of defense of the innocent, there is neither counsel nor officer nor money." Those whose ability commands a law business are seldom chosen for court appointment. The appointees come from failures in the profession who hang about the courts hoping for a stray dollar or two from the unfortunate, or from the kindergartens of the profession, just let loose from study and anxious to learn the practice. They have no money to spend in an investigation of the case, and they come to trial wholly unequipped, either in ability, skill, or preparation, to cope with the man hired by the state. Having painted the scene plainly and harshly, she then called forth her creation. For every public prosecutor, there should be a public defender, chosen in the same way, paid out of the same fund. Police and sheriff should be equally at his command, and the public treasury should be equally open to meet his legitimate expenses. Now, there are two things to note about Fultz's defender. One is that she would represent everyone who asks, not just the indigent defendant. And anybody can still have private counsel in addition to the public defense. They can have both, because she believed that justice should be free for everybody. Innocent men should not have to pay for their own defense, bankrupting themselves and ruining their families in many cases. Secondly, she believed that all were innocent in the eyes of the law. The presumption of innocence should be treated as a right of individual distinctions, of individual defendants. And there was no distinction for her between the actually innocent, the factually innocent, and the presumably innocent. She said the law makes no such distinction, and we should make no such distinction. Now, this idea, as well as having a theoretical basis, was also strategic, because she foresaw or knew that a defense lawyer, a public defender, would never receive the real respect and equality if they represented only the poor and the indigent and the despised. Now, the other thing to note about Fultz's public defender is that he was born as an oppositional figure. He comes off of Wells, and she wrote, in support of the public defender, she wrote an article called Public Defenders, but she also wrote one called The Duty of the District Attorney in Criminal Cases about the prosecutor. And she cited in this article over 200 cases. Now remember, this is before you have your automatic research skills on your computer. Over 200 cases from all over the country of prosecutorial misconduct. And she pointed out that these cases were only a fraction of the cases that actually existed, because poor people cannot appeal their convictions. At one point, she has an antic piling up of examples, hundreds of citations. She has the choice vituperative literature aimed at the accused, and here are some of the examples. Black thief, black as hell itself, bloody assassins, butcher boy, contemptible brute, grocery bully, midnight assassin, mean, wicked, low-down, dirty devil, pusillanimous puppy, sugar-loafed, squirrel-headed Dutchman, terrible desperados. So went her list of justice-polluting epithets. Her point was that prosecutors had lost their way, that they had forgotten their original role as ministers of public justice, concerned for the welfare of all the people, including the accused and his community. This figure of the public prosecutor, this ideal of the public prosecutor, was almost as striking at the time that she wrote about it as her idea of a public defender. And her argument was that the prosecutors had fallen from their high ideal and thus made a public defender necessary. And this was one of her main points. After the fair in 1896 and 97, she drafted a statute and mounted a nationwide campaign for its introduction in state legislatures. Though it made a splash in the popular and professional press, the Fultz Defender Bill did not pass anywhere. But Fultz continued for the rest of her life to offer her bill to any legislature she came close to. If she happened to be passing through to make a lecture, she would go to the Capitol and get somebody to introduce her public defender bill. By the end of her life, she counted 33 states where it had been introduced. She also took credit for the first public defender office established in Los Angeles in 1913, an outgrowth of the progressive movement which bloomed early in California, and an outgrowth of the very closely linked woman suffrage movement. 12 public defender offices were founded between 1914 and 1926. Moreover, as a result of the stir about conditions in the courts and the need for lawyers, some jurisdictions that did not adopt a public defender did start providing payment for appointed lawyers. By the time that Gideon was decided in 1963, most states had some provision for paid public defense. And post-Gideon, hundreds of public defender offices have been established. Excuse me just for a minute here. Now, Fultz's experience as a woman trial lawyer is the place where she got her idea for the public defender. Other women had similar experience, and so I wanted to bring you a special gift today, which is some of your own history here from BU, and talk about the criminal practice of another woman, a friend of Clara Foltz's. You see, in fact, it reminds me of when I first started in law teaching. I really knew of all the other women in law teaching, and today that would be impossible. And the same was true of the early women lawyers. They all knew each other and knew each other's cases. So Lillian Robinson, have you heard of her? How many people have heard of her? Well, good. Now you all will have heard of her. She's your history. She was the first woman to attend Boston University Law School, matriculating the same year, 1878, that Clara Fultz became a member of the bar. Though she was the first and only woman in the school, unlike Hastings, she was admitted freely at BU. Her big worry in coming to law school was not about getting in and the attitude of the men toward rustling skirts, but was how to deal with fellow students, given that no lady should speak to a man unless they had been formally introduced. So how she was going to get started was quite a problem. She worked it out and did well at her studies, finishing 4th in a graduating class of 32. But the Massachusetts court would not admit her to practice on account of her sex. In 1880, citing Clara Foltz's case in California, Robinson did the same thing that Fultz had done. She lobbied through a woman lawyer's bill and became the first to take advantage of it. But even duly licensed, she had no offers of employment in Boston. So she hung out her shingle and found, as she later wrote, that the embarrassments and difficulties she encountered without prior training in an established office are such as none but those who have experienced them can ever realize. Frustrated because the little business she had was office work, and feeling that the public judges a woman lawyer as it does a man, largely by his success in court, Robinson set out for the West. Washington Territory had adopted woman suffrage, and women were serving on juries there. She figured on courtroom opportunities in a place so liberal on the woman question. setting out by herself for the far West at a time when even traveling alone on the train was a little questionable thing to do. Practically upon her arrival in Seattle, Robinson was appointed by the judge to represent the indigent accused. Though, she said, the sound of my own voice in public was quite unknown to me, she was soon defending poor people before mixed juries, that is, juries containing men and women. She was the first woman in the world to have this experience, and she later wrote that if woman jurors failed in either direction, it was in sometimes being a trifle too logical, not allowing sweet pity to have its fair influence. Robinson complained of a particular woman juror who thought my Chinese client to be guilty, whereas he was really quite innocent. The following week on another case, my first peremptory challenge was expended on this lady, whom I did not dare trust again. Thus, in Washington Territory in 1885, Lillian Robinson became not only the first woman lawyer to argue to a mixed jury, but the first to strike a woman from the panel. Now, Clara Fultz drew from her experience the idea of a public defender. Lillian Robinson drew from hers the first important article on women jurors and why women were qualified and competent to be on the jury. It's not always recognized that jury service, along with suffrage and the right to be a lawyer, were all three interwoven goals of the women's movement. Interwoven because if you let women vote, they will then want the other big chance to participate in government directly, which is to serve on juries. If you let women be lawyers, then you'll have to put them on juries because only women can resist the feminine wiles of other women, and so forth. These arguments were actually made. Lillian Robinson found that she was good at criminal jury work, and she was also delighted with the place, the climate, the people, and the bright new civilization in Washington Territory. But she grew lonely for her parents and sister in Boston, who had reneged on their promise to follow her. By 1888, she was back practicing in Massachusetts, not doing much in the criminal line again. Yet she found it easier to get established at home this time around because she had been so broadened and liberalized by my experience in the West that my own greater self-confidence helps people more readily to place confidence in me. She wrote several popular books explaining the law with this wonderful title, Law Made Easy. She then met a piano dealer named Eli Sawtell, and they fell in love. And they honeymooned in Washington, D.C., where Robinson took the opportunity to join the bar of the Supreme Court in the same month that Clara Foltz joined in 1890. Sadly, Robinson died an untimely death from an overdose of pain medication just a year later, but she is a very fitting first woman for Massachusetts and had a brilliant, if untimely, short career. Now I want to return to where I started. The conditions that gave rise to public defense to start with exist perhaps even more today. The gulf between the rich and the poor in the kind of defense that they get, the different kind of justice for each, the politicization of crime, the creation of a criminal class, draconian sentences, unspeakable conditions of incarceration. In many places, the prosecution is unchecked and out of control. The concept of ministers of public justice is threatened today, just as they were in Fultz's day, though it takes different forms. It is the same result that we are on the road to replacing public justice with private revenge. Consider the deference paid at sentencing to victims seeking closure, or the corporate complaining witnesses who provide the prosecutor with exhibits and experts and maybe a job later. The elite bar, unaware, uninvolved, as it was in Clara's time. The widespread adoption of public defense has had the unintended consequence of walling off the criminal practice from general professional concern. Leave it to the public defender is the attitude. Yet few public defenders have the resources even to give effective individual representation across the board, much less to counter the prosecutors systemically or to lobby for adequate resources to meet inevitably increasing caseloads. 4 years ago, on the 40th anniversary of Gideon, there were, as there usually is on the anniversary of Gideon, every decade or so, detailed reports, a very serious study by the ABA, lamenting the failed promise of Gideon and saying that hundreds, perhaps thousands of people are in jails and prisons. People are even on death row who have not had the advice of competent counsel. It is time to renew the original understandings and founding aspirations of public defense as conceived by Clara Foltz, enacted by the progressives, and envisioned in Gideon. From her experiences as a jury lawyer and feminist crusader, Foltz fashioned a powerful, resourceful figure to counter and correct the prosecutor, to balance the presentation of the evidence, and to make the proceedings orderly and just. Her defender would engage the law's presumption of innocence on a deep level, investigating for favorable evidence, summoning witnesses, seeking expert testimony, and preparing to cross-examine. He would also plea bargain, but only after preparing the case so that there was something to bargain with other than the defendant's right to trial. He would work with the prosecutor's office in designing fair procedures for producing favorable evidence, for instance. He would support programs for rehabilitation and treatment of offenders and would lobby on behalf of bills to make the right to counsel real for all the accused. Let the criminal courts be reorganized upon a basis of exact, equal, and free justice. Let our country be broad and generous enough to make the law a shield as well as a sword. Clara Fultz said that in her peroration at the World's Fair, and in return, she promised the blessings which flow from constitutional obligations conscientiously kept and government duties sacredly performed. That promise holds true today.
To Barbara, that was great, and it reminds, we don't think of this every day, but it reminds the younger women on the faculty how much we owe to the women who came before us, as well as the uppity women of the
19th century. The 19th century, right.
So we have some time for questions, and again, if you could just wait for the microphone to get to you. Just raise your hand. There we go.
Yeah.
What practical changes you think would be necessary to satisfy the dream of improving the public defender system?
That I like that question, and I think actually what we need is for the bar to get involved, and for people to think about public defense as part of the pro bono obligation. Or supporting public defense. It's a lack of a lobby. The criminal codes have almost for criminal defense. And what happens with every public defender is they often start with the highest ideals and good offices, but they just cannot keep up with the resources. Can't keep up with the caseload, and then there's just tremendous pressure on the offices to get the people in court and process the cases, and take care of a few people that might be factually innocent, but the rest, let's just get the best plea we can. It becomes this happens too often, and I think it really is because it's hard to it's not a popular idea, public defense, defense of the accused. And I don't know. In some ways, the Innocence Project. I see that you have the leaders of it, and I applaud that. That although I wrote an article once called "Defending the Guilty," which is if you are a public defender, that's the question that your grandmother asks you as soon as you every Christmas, like how can you defend people when you know they're guilty, but that is the idea that the Innocence Project confronts that idea and says there are people that are innocent, but the focus on the people that are innocent is to the detriment, I think, or to the neglect of the people who are lacking due process or receiving sentences far in excess of what they did or who haven't had a fair trial. So that the interest in the sorting mechanism is different. The other thing that I was just thinking practically, though it's the hardest thing to do, it is that we defenders, we people who have always, and I was as guilty of this as anybody, but I don't know if this is just getting old and conservative maybe, but I really think that the gulf of misunderstanding and dislike between prosecutors and public defenders, which exists, the enmity and the real sense that nobody who had the true soul set to be a great public defender could be a prosecutor, or that no good person would be a prosecutor, and that just makes the system full of adversariness and mistrust. And I was just thinking if there would be some way where prosecutors and public defenders could be trained together, and where people might think of moving from one office into the other office, that would be the kind of career. Somebody who's been a public defender, well, it's very hard for them to ever be appointed to be a federal judge, whereas many, many federal judges have been prosecutors. Have you noticed that? I bet you haven't noticed that. But if you'd been a public defender, you would have noticed it, let me tell you. And I tried very hard to get an extremely capable man appointed in Washington, D.C., and his being a public defender was disqualifying in some sense. And I think maybe that kind of step, and in law school, too, of people thinking that they would do both, that they might do both, and giving up the idea that it takes a very brave and a particular soul set and heart set and spirit to be a defense lawyer, which I used to think and promote, and not want to hire anybody if they would even think of being a prosecutor. And now I think that may have gotten us to where we are today. I mean, that attitude, because people say, well, if they have their own little club and we're not responsible for it, and this idea that criminal law is such an arcane specialty. If you're a litigator in a law firm, you can try a criminal case. Let me tell you that. And the skill of litigation that's the skill, and it doesn't matter what the subject matter is. If people felt responsible for it and for the criminal justice system. So that's what I think. I want to say one thing that I think is a mistake, that I made a mistake when I said the colonies had constitutions that had a Sixth Amendment. The states, all the early states did. I don't know what do you know what the colonies did? I think some colonies did. I doubt it. Yeah, I think that was one of the things when the states started making constitutions, their state constitutions. But every state constitution, it's kind of striking. The first ones all included this right to counsel, but it was a right to have a lawyer as opposed to no lawyer, but not to have a paid lawyer. More questions? Yes. Wait for the microphone. Oh, are they? Well, we could start back here and then come up here. My understanding is that
of the people in law school today are women, and I'm curious over your career if you've seen, what kinds of changes you've seen in the profession, given the shift from basically it being a male profession to being, a profession with a very large number of women.
A mixed profession. Yeah. I think we're just beginning to see the results now. See, because it only has happened. When I graduated in 1963 from law school, there was 3% of the nation's law students were women. And by 1970, it was 20%. And one of the first results was these were women. These women in the 70s were women who were coming off of the civil rights movement, and they just arrived. They had a completely different attitude than we had, which was our attitude was, thank you for letting us come, and we had lots of comments about you're taking a man's place, a man who's going to have to earn a living for his family, and you're taking this place, and we actually dealt with that like it was a sensible comment. And but these new women, they were like, where are the women teachers? And there are no women in the curriculum. And why don't we have any subjects? And they were marching and demanding. I never saw such women. I mean, they just knocked me out. And that's how I got from being a public defender to being a Stanford law professor. It's not the usual career path. But it was the women demanding that the school produce some women professors. So that's been just overall immediate change, that women professors, the number of women, it changes the classroom to have this different mixture of people in it. And I'm hoping that women might be the answer to the public defender, too. See, that the idea of the defense and maybe of combining it, of a career as a public lawyer, doing some time as a prosecutor and defense, is some idea that women, that might be especially appealing to women. But it's measured. Right now we're going through a period where the law firms are, which is still the way most people practice law, and they are they are just increasing the amount of work that lawyers do. I mean, I was just the other day at this law firm that's considered a lifestyle law firm in San Francisco was bragging they only require 1,800 billable hours. Well, that's too much. And so that women are. I think that women are going to change the profession in this way too. I mean, they're not going to work these inhumane hours that leave nothing for pro bono publico or family or community or the things that lawyers used to do. I think women are going to revolutionize the profession. But so far, you see, we haven't really, so far all women have been able to do is assimilate, and start with these ideas, and find the places. But now I think we're getting into numbers where we can change things.
You tell a terrific, kind of heroic story of Clara Fultz, and I think it's a wonderful story, and it's clearly necessary to understanding where the public defender came from. But I wonder if you could tell a little bit more of the story of the origins of the public defender, how this kind of crusading got translated into the actual institution. You mentioned, for example, the 1913 founding of the Los Angeles, I think you said,
yes,
Public Defender's Office.
Yes.
So there's a long way to go from the lone crusader to actually implementing something like this.
It is, and it happened in a short amount of time. I'm glad you asked that question. And let me recommend my article called "Inventing the Public Defender," and it's in the American Criminal Law Review, just out, this current issue of the American Criminal Law Review, and it tells the rest of this story. But it's connected to suffrage, and that's what I'm writing about, in this odd connection. And so that's the reason that I answered your question that way, because the two institutions have been connected, not just in the person of Clara Foltz, but generally, that one of the things that the suffragists sought was the public defender, and it was the idea, it was combined with the progressive movement, but there was just a general concern about the criminal justice system was one of the things that needed reforming, and having lawyers for the criminally accused would be one of the reforms, and separating juveniles and adult offenders, and having a special children's court or juvenile court, and all of these were reforms that women were going to bring about when they had the vote. And so that was, and then that was tied generally with the progressive movement in California. This was one of, there were other kinds of governmental reforms, like the referendum and the recall, and a department to purify milk, that a government department that made sure that the milk and food supply was healthy. These sorts of things that women said, this is what we're going to accomplish with the vote. And this idea that the public defender was something that women were going to accomplish with the vote. I mean, it sounds like a kind of wild idea, but it did happen. It happened. But this history, as I say, this beginning history has been somewhat lost, that women were at the heart of the first public defender offices and of the movement itself. But that's it. But read the article, and you'll get, and the footnotes. You'll see everything you could want to know.
Great. Well, I know people have class at 2:10, so I want to leave some time for you to chat with Barbara on your own. And again, the reception is in the lobby of the auditorium. And Barbara, again, thank you so much.
Oh, you're welcome. Thank you.